We're going to get started. Okay. We're being co-hosted today by the Allegheny County Law Library. Here's a slide of information for anyone who's interested in pursuing their services. We've also got a representative of the ACLL here today, so talk to Nick. I'm going to tell you a little bit about PMC before we get started. This is Pennsylvania Intermodern Courts, and we are a nonpartisan nonprofit that envisions a Pennsylvania judicial system in which everyone is assured impartiality, accessibility, and respect. We are not offering legal advice today, but we hope this presentation is informative. We will be sending out these slides and a recording of the presentation afterwards. So if you signed up for this workshop, you'll be getting that in your inbox. If you didn't, just leave your email address with me, and I'll get that to you. On behalf of PMC, thank you for joining us. Thank you to the Carnegie Public Library for hosting us and the Allegheny County Law Library for partnering with us. We have with us today Holly Glymour and Samantha Dorn to speak about family court. And they're going to be taking us away, starting with court basics. So I will turn the podium over now.
All right. Thank you, everybody. Good afternoon. It's so wonderful to see you guys here today. So it's important to understand how our court system in Pennsylvania is structured. So there are actually 51 different court systems within the United States. We have one federal system, and each of the 50 states has their own state court system. So you see this pyramid up here on the screen or on your screen, and this is how Pennsylvania divvies up its courts. You have the municipal court and the magisterial district courts at the very bottom. Then above that is the Court of Common Pleas, which is what we call our trial court. Above that is our intermediate appellate courts, which consist of two courts, the Superior Court and the Commonwealth Court. And at the very top is the Pennsylvania Supreme Court. The most, if not all, family court cases are going to begin at the Court of Common Pleas. The only exception would be if you needed to obtain an emergency PFA, you can obtain that at your local magistrate or at the Pittsburgh Municipal Court instead of having to go down to the main courthouse, to the Family Law Center on Ross Street. Our courts are administered by a president judge who is elected by all the other judges who are sitting in our Court of Common Pleas. There are, I think, 43 total judges who sit in Allegheny County. And we had 8 new judges that were just recently elected in this past election. So all the courts are presided over by the president judge, and the Allegheny courts are divvied up into 4 different divisions. You have civil division, criminal division, family division, and orphans court, which handles wills and estates, probate, and most adoptions. We are going to be focusing on what occurs within the family division. One thing to note before we start getting into the substance is that if you are what's called a limited English proficient speaker, if English is not your first language, you have a right under law to have an interpreter available in your language. These are professional interpreters that are contracted with the courts to provide these services. These services are free, and we want a professional to interpret. The court really does not like for family members and friends to interpret in court proceedings. This is mostly to avoid the appearance of bias towards one party or the other. And another thing is that interpreters speak at what's called a different register. They speak in that more sophisticated vocabulary and they know how to best translate all of the legal words that we use in the courts into what's called the target language, the non-English language that somebody speaks. The courts will also provide interpreters for people who are deaf or hard of hearing, as well as other accommodations for people who have disabilities. If you are visually impaired, if you use a wheelchair to get around, for example. These are all provided again, at no cost by the courts. But you need to let the court know as far in advance as possible. Generally, I would say as soon as you figure out when you're going to be in court, contact court administration to request those accommodations or to request an interpreter. Especially if you need an interpreter for a foreign language, because some of the less common languages that are spoken in Allegheny County, for example, something that's not like Spanish, French, Chinese, etc., Nepali, we may need time to find those interpreters. And so it's best to let court administration know as far in advance as possible that you need someone. And to do that, there is a form that you complete. It is available on the 5th Judicial District's website. And the website is listed there on the slide. And then you would email that completed form to court administration. And again, that email is also listed on the form for you as well. Anybody who is participating in a court proceeding can have an interpreter. If you're a party, if you're a victim in a criminal case, a witness, parents, somebody who is acting in loco parentis to an incapacitated party. And if you need an interpreter to communicate with staff outside of the courtroom, they are able to provide interpretation services, typically through telephone, if you come in just wanting, not because you have a hearing, but you just need to speak to someone, get information. There is a telephone service they can call up and find an interpreter in your language that can provide those services for you. And again, that is all of no cost. So the location of the family division, it is located on Ross Street in what's called the Old Jail. It's the building that is directly behind the Allegheny County Courthouse. It's connected with that Bridge of Sighs you may be familiar with. The entrance to what's called the adult section, where divorce and custody and child support matters are held, that is on the side that faces Ross Street. The juvenile section, where dependency cases where CYF is involved, or delinquency cases where a juvenile is charged with a crime, that entrance is on the 5th Avenue side. So it's one building, 2 separate entrances. So like I said briefly, we're in 2 different sections. Juvenile section is dependency, delinquency, termination of parental rights, and other matters along with that. An adults section, they are the ones who deal with child support, custody, divorce, protection from abuse cases, and those other issues. In Allegheny County, we have a policy of 1 judge, 1 family. And that means that when the judge hears a case involving a family, the judge will continue to preside over all of the matters within family division that affects that family unit. So, for example, we've had a few of these cases come up in my own experience as a law clerk, where we have the parties come before us in the adult section in a typical custody proceeding, and we'll talk in a little bit about what that process looks like. Then we find out that CYF has filed a petition for dependency. CYF wants to remove the children from the parents' care because they believe there is some sort of safety risk going on. The judge who is hearing that custody proceeding in the adult section will also hear most likely will hear the dependency proceeding going on in the juvenile section. So it's the same judge dealing with the same family. And oftentimes, if there are multiple family units, so if it's one parent with multiple court cases, dealing with multiple children with multiple fathers, multiple mothers, whichever, often the same judge will hear all of those cases, since it all is part of the same family unit. And again, this is just an explanation of what the family court does. There are various departments, and those are listed on the 5th Judicial District's website. So for this workshop, we're going to be talking about 4 main substantive matters. We're going to be talking about divorce and spousal support or alimony, child support, child custody, and dependency court. I will reiterate what Nina mentioned earlier, that this presentation is not a substitute for legal advice. It should not be construed as legal advice. We highly encourage you to seek out legal counsel for assistance and questions regarding your own specific case, whether it be done privately or through one of the family law clinics, either at Pitt Law School or Duquesne Law School or some of the other legal aid agencies in the area. So let's dive right into it and talk about our first topic, which is divorce. The first thing to know is that under the law, there are 2 different kinds of divorce. There is fault-based divorce and no-fault divorce. And we often refer to them based on these numbers and letters, 3301A, 3301C, 3301D. That's the name of the section that they appear under the Pennsylvania Divorce Code. Just so you know, the words fault and no fault are really just legal labels that are attached to the 2 different processes that you go through. They do not invalidate the way that you experienced your marriage or what happened during your marriage. It's just, it's a way to distinguish the 2 different processes. So if you are seeking a fault-based divorce, that's under 3301A. I will say that this does not happen very often anymore. One of the reasons being is that it is very complex. And in order to obtain a divorce on fault-based grounds, you have to go in front of a judge and have a hearing. After having a hearing and hearing the testimony and the evidence, a judge can grant you a fault-based divorce if you can prove the other spouse committed one of several actions. If they abandon you without reasonable cause and they've been out of the house for at least a year, we call that desertion. They cheated on you. If they put your life and health at risk through domestic violence, for example, we call that cruel and barbarous treatment. If they married you while they were still legally married to another person. If the spouse has been sentenced to prison for 2 or more years for committing a crime, or if they've behaved in a way that made your life unbearable or extremely difficult. The legal word we use for that is indignities. By and large, the vast majority of divorce cases that come through the courts are called no-fault divorce. And there are 2 different flavors of no-fault divorce. The first option is under Section 3301C. And this section allows for divorce if both spouses consent to it. And how this works is that one spouse files a complaint for divorce, and they have to go through the process of serving it. And 90 days after serving it, both spouses can file an affidavit of consent to the divorce. And just as an aside, if a conviction for a physical crime against the other spouse is deemed consent under the law. After doing the affidavits of consent, you file a document called a waiver of notice or a notice of intention to request entry of divorce. Basically, these are documents saying that, telling the other spouse, hey, I'm still filing for divorce. Let us know if you contest this or not. After those documents are filed, there is actually one little extra point there, is that the court would issue an order approving grounds for divorce. And after that's done, One spouse will submit what's called a precipice to transmit the record. It then goes to the court clerks who review everything, make sure everything it has procedurally done. And if all the boxes are checked off, you will receive your divorce decree. And just so you know that in Pennsylvania, there is no such thing as legal separation. You are considered to be married until the divorce decree is finalized and entered on the docket. If your spouse does not consent to a divorce, you can file for no-fault divorce under Section 3301D, which is basically saying, that there is what's called an irretrievable breakdown of the marriage. Basically, the marriage is broken down. There's no chances of fixing it. There is a waiting period with this. If you separated on or after December 5th, 2016, you have to live what's called separate and apart for 1 year. If you separated before December 5th of 2016, it has to be for at least 2 years of separation. Now, living in separate and apart, it really just means that you're not living as spouses. There is cases that say that you could still be living under the same under the same roof in the same house, but still be considered living separate and apart from each other because you're not acting as a married couple anymore. After filing and serving the complaint, you would prepare what's called an affidavit under 3301D and several other forms that go with it, serve them on the other side. You have to also do what's called a certificate of service, which tells the court how you served them. The other side has to fill out what's called a counter affidavit, basically saying whether they agree or disagree that the marriage has broken down or not. In most cases, they do agree that the marriage is broken down, fortunately. And then, just like under 3301C, you end with filing a precipice to transmit the record, and then your divorce decree gets entered. Some important things to know about filing for divorce. First is that it can be difficult to go through the divorce process without an attorney representing you. This is especially true if you are dealing with issues like dividing up property, what we call equitable distribution, or if you want to get alimony from the other partner, or if you want what's called exclusive possession of your home, meaning you want to be the only one who lives in the marital home. If there are other issues like that going on, it is highly recommended that you seek out a lawyer to help you through the process. Whenever you're filing, always make sure to pay attention to the deadlines and to mandatory waiting periods. For example, if you file your affidavit of consent before the 90 days, it will not be counted as valid in the court's eyes. One reason why it's important to get a lawyer if you have issues like support or equitable distribution is for one very important reason. If you get the divorce decree and you haven't resolved alimony, property division, any of these other claims, we call them, you cannot file a new complaint to try and get them resolved. So if you have issues like that, if you have property that needs split up, if you have alimony, if you want to ask for alimony, all of that needs to be brought to the court's attention at the time that you file the complaint for divorce. And as I stated earlier, no-fault divorces are the most common, not just because they're the cheapest to attain, but because they are the most straightforward. They don't require, a lot of times they don't require going before a judge. If you have to go before a judge or a hearing officer in a no-fault divorce, it is almost always because of determining the distribution of the property or determining spousal support or alimony, or other matters that might have been brought up aside from the divorce. All right, so now I will turn it over to Holly, who will talk about support.
Hi, everyone. I'm Holly Glymour. I am the supervising professor of the Family Law Clinic at the University of Pittsburgh Legal Clinics, and I'm delighted to be here today to talk to you about some of the basics of family law. So when we talk about support, oh, no, what am I doing wrong? Yeah, when we talk about support, there at its core are two types of support that the family division handles. The first one is child support, and the second one is support of a spouse. And you are entitled to receive both of those, one of those, neither of those depending on your circumstances. And they are handled through a separate path than custody or divorce. You can file for support even if there is no divorce. You can file for support even if you're not ready to get a divorce. You can file for support if you have a child together but you've never been married. So it's important to know what you're asking for and what you're entitled to. There are three types of support for a spouse. One is spousal support, one is alimony pendente lite, and one is alimony. The first thing to be very clear on, you are not entitled to spousal support unless you were married. That's the basic. You got to be married to be entitled to spousal support. When we go through the three types of spousal support without trying to overcomplicate things, spousal support is what you would file for if you and your spouse are separated, but no one has yet filed for divorce. Alimony pendente lite is what you would file for if there is a divorce pending, but it is not finalized. Alimony is something that we would call post-divorce support, where you can get support after your divorce is finalized if you qualify under the statute. So what are the difference between these forms of support? So spousal support is the one you file if you're married, but you're separated, right? And no one has filed for divorce yet. And as Samantha just rightly pointed out, you do not have to have filed for divorce to be separated. You don't have to be residing in different homes to be separated. If so, it is a question for the court of fact as to whether you are separated and have begun the separation period and whether you might qualify for spousal support. You can file for spousal support even if you're in the same home and no one has filed for divorce yet. My caveat there is that in general, the courts do not order spousal support if you're living in the same home and you are still being supported by the higher earning spouse. So what can that look like? That can look like the higher earning spouse paying the mortgage, paying the utilities, paying the general expenses that have existed during the marriage. You would have to show the court that on some level, they are not providing an adequate amount of support for you. So that would be the first barrier in spousal support. Now, if you're living in different homes, whether your spouse moved out, you moved out, doesn't really matter. You sold the house and you're living in different places. If you're living in different homes, spousal support is available without needing to show that that base of support is not being met. And the difference is you're living in an attacked home sharing expenses versus not. Spousal support is paid by the higher earning spouse. So if you make the same amount of money, you're not getting spousal support. But if you are a lower income spouse, you are a stay-at-home parent, you've always earned less, you have a job, but you don't make anywhere near what they make, you are entitled to support from the higher earning spouse. And that can include other things, such as continuing your health insurance coverage, paying a certain percentage of your unreimbursed medical expenses. Spousal support isn't just about the dollar amount you get every month, although that's a big part of it, but it is about continuing to provide certain necessities as a spouse. The thing about spousal support that's a little bit different from alimony pendente lite is that if your spouse can show that you've committed fault and you're asking for spousal support, you are not going to be entitled to it. Fault is a bar to spousal support. Why does that matter? Alimony pendente lite doesn't have that rule. Everyone can have committed the worst fault in the world against their spouse and everyone can agree. But alimony pendente lite, which is essentially spousal support when there's a divorce complaint pending, you cannot reject giving it to the lower income spouse because they committed fault. So if you are a lower income spouse and you believe that your spouse may use a fault-based defense against spousal support, you may want to file for divorce and then file for alimony pendente lite. But the other thing about alimony pendente lite is that because it is a statutory obligation versus a common law obligation like spousal support, the statute says exactly how much you should get. There is a formula for it that breaks down based on your income, your spouse's income, and percentages, and whether child support is being paid. And the court tends to default to that statutory, here's exactly what you're going to get. They might offset things if your spouse is covering expenses for you, but that is the amount you will get. Alimony pendente lite generally will start as soon as you file. It'll be retroactive to the date you file. It ends by law when the marriage ends and when your divorce decree is issued. There are some exceptions. If you have a particularly short marriage, sometimes the court will not let you receive alimony pendente lite past the length of your marriage. So if you were married for a year, but you want alimony pendente lite for 2 years while you're going through the divorce, that may be an argument that has to be had in front of the court. But generally speaking, going to be retroactive to the date you file and with the divorce decree. And then alimony is a whole separate type of deal. With alimony, you are looking at the alimony statute to see if you qualify for alimony under the multiple factors in the statute. And the factors are things like, how much did you make during the marriage? How much did the spouse make during the marriage? What was your standard of living during the marriage? Are you able to provide appropriate support for yourself? If you're not, what would be involved in getting you to a point you could provide appropriate support for yourself? Did you support your spouse's career? Did you help them get degrees or attain higher income? And one of the big things we're looking at here is that, especially in Allegheny County, but in general in the state, alimony is a sort of secondary remedy, which means it's not the preferred way of dealing with financial differences between the spouses post-divorce. And the reason for that is that it continues a level of engagement that often is not in the best interests of the spouses, because you have to continue to get monthly money. You have to continue to engage with each other about that money. If it doesn't get paid, you have to deal with wage attachments and contempt. So if there's a way to give you more of the assets, say 60% rather than 50%, and be able to not do alimony, the courts are going to generally want to do that. Now, that's not always possible. In short marriages, sometimes that's not possible. When there aren't a lot of assets, that may not be possible. If all of the assets are caught up in retirement, which means you can't get the money easily, immediately, then alimony is going to come into play. It does still exist, but it is worth being aware that it is considered the less preferable way of making spouses financially more whole. Alimony is not set according to some sort of formula. It is, each spouse will have to do budgets. They'll have to talk about reasonable expenses, reasonable income. They will try to figure out what is a reasonable amount the other party can pay versus what the party receiving it may need. And sometimes there simply isn't enough money to go around. But that is how they look at it. It's a holistic review rather than the formula that comes with alimony pendente lite. It is worth noting, in addition, that the court often will try to tailor alimony decisions specifically to events, right? So if you're 62 and you're going to get Social Security at 65, they may look at doing alimony until you're 65. If you're in school to sort of build up your income earning potential, they may look at doing alimony until school is over. So it's generally not open-ended and long-term the way you may have heard about in the past. Child support is a different matter. Don't have to be married to get child support. You simply have to have a child with another party. You may need to prove paternity before child support can be ordered, and there's a fairly simple process for doing so through the court. But if you have a child together, you may be entitled to child support. In general, child support is going to be based on figuring out parent A's net income, parent B's net income, combining them, figuring out how many children they have, and then looking at a chart. There is a chart that the state publishes that says if the parents' combined net income is X and they have 3 children, you go down the chart, over on the chart, and that is how you determine how much money should be going to child support every month between the 2 parents. It is a pretty structured statutory rule. Also related is the custody schedule. The custody schedule helps determine who is entitled to child support and how much child support. If you have 50-50 custody, right, same number of overnights every year to each person, then the person who makes less is entitled to child support. If one party has the children with overnights more often than the other party, that parent who has more overnights is going to get the child support from the other party, even if the other party makes less than that parent. So these are all things we have to think about when figuring out child support. Child support includes a monetary cash monthly amount that can be paid by wage attachment, ideally, if the person paying works and has a paycheck to pull from, or from SSDI, like Social Security Disability, or for older parents from Social Security in general, or from unemployment sometimes. That is generally preferable, and it is what the court will default to ensure the support is paid. However, parties can agree, or if someone's self-employed or not employed, they can be ordered to pay directly to the state, and then it will come to the person receiving it. That is the monthly amount of child support. But there's also, we look at dividing costs of childcare that are involved in work, not cost of childcare to go out in the evenings, but if you need daycare because of work, if you need a babysitter because of work, those sorts of things can be split between the parties. Cost of health insurance premiums, cost of education. Sometimes the education thing, if you enter into a situation where you have both agreed to private schooling, that can be split. However, if only one party wants private schooling, unless there's a very good reason for that, they're generally going to bear the cost. If the parties agree upon extracurricular activities or the reasonable amounts, that can be split. Unreimbursed medical expenses, usually the person receiving child support pays the first $250 per year. Anything over that, co-pays, deductibles, things of that nature will be split. And it's split based on income, not default 50-50. So if one party makes 75% of the income, they're supposed to pay 75% of these expenses. If one party makes 50%, they'll pay 50%, and so on. This talks about the calculation for child support. Like we talked about, use the chart to figure out the cost of the children's basic needs. Then we figure out what percentage of the combined net income each earns monthly and what the custody schedule is. This is a really good example. If you and the other parent earn $10,000 per month net, and net is just after taxes and mandatory retirement, not 401ks. We're talking pensions you have to contribute to. If your combined net income is $10,000 per month and you have 2 children, the chart would show us that the cost of the child's expenses is assumed to be $2,280 per month. If you earn 25% of that net income, then the other parent will pay you 75% of that set amount they believe the child should cost if you have primary custody. However, if custody is shared, it's going to go down, because it's going to account for that person having more time and paying more direct expenses for the kids. Anything between 40% of overnights to 50% of overnights is going to reduce the amount of support that is paid to the other party. Also, if you have 50-50 overnights, exactly the same number of overnights, there's something called income equalization, which essentially says the person paying child support, no matter what these guidelines and calculations say, if they have half of the overnights, they cannot pay you more support such that you would have a higher income than they do. So even if support's supposed to be $1,000, if your income difference is only $500, then they'll pay you $500 so you have the same income, but they're not going to pay you the $1,000. I know that's a little complicated, but the basic theory is if you're paying child support and you have equal number of overnights, you should never have, your child's reports should never cause you to have a lower income than the other parent. Additional expenses we talked about, after school programming like extracurriculars, childcare costs to work, medical insurance, unreimbursed medical expenses in proportion to the party's income. We get a lot of questions about what's an unreimbursed medical expense, deductibles, copays. We're not talking vitamins you buy or chapstick. This doesn't include things like haircuts or prom costs or school pictures. You can certainly divide those if you choose, but here we're really looking at sports, tutoring, extracurricular classes, deductibles, copays, things of that nature. For support, you will file a complaint in court. That would be true whether you were filing spousal support or any version of that, except for alimony, which is handled as part of the divorce, or you would file a complaint for child support. If there's a question about paternity, the person who you file against this questioning paternity can ask to establish paternity. That would usually involve genetic testing. Then there's a conference with the domestic relations officer. That takes place over the phone in Allegheny County. This varies by county. Some counties will do it in person or over video. Allegheny County does it by phone. And the conference officer or the domestic relations officer will run numbers for you. They'll use the calculation. They'll listen to what you have to say. They'll look at your pay stubs, your tax returns, things like that. And they'll try to get you to agree to a final order. You're not required to agree to final order, but you can. In Allegheny County, the conference officer can enter an interim order temporarily until you have a final hearing if it is your first child support proceeding or spousal support proceeding. Other counties have the domestic relations officer enter an interim order, and then you have to appeal it if you don't like it. So it does get a little complicated by county, but we'll stick with Allegheny County. If you don't reach an agreement, the parties will go before a support hearing officer. And in Allegheny County, these are hired by the court. They're lawyers, they're not judges, but they have a lot of the same powers as judges. They will hold a hearing, they'll go on the record, they'll take testimony from every party, and they'll take documents that are evidence, and you can make your argument, and then the hearing officer will make essentially a recommendation or order. This is just like any other hearing. It's formal, it's on the record. However, it is short. They tend to be about 15 to 20 minutes. So you got to come in ready to go. In the event that the hearing officer makes a recommendation and you don't agree with it, you think it's wrong, you can file what are called exceptions to the judge, and the judge can review it basically under an abuse of discretion order to see if something was done incorrectly. That's a complicated process, but it can absolutely be done. In other counties, they have a process that's called a de novo hearing, which is essentially where you go in front of the judge and you re-argue the whole case. That's not in Allegheny County. We just do exceptions with the abuse of discretion standard. But if you're in somewhere like Westmoreland, you have a right to request a whole new hearing in front of the judge. So it's important to know what county you're in. If exceptions are filed, you're given a date before the judge. You explain why you think the hearing officer abused their discretion. They won't take new evidence. It's just based on the record. And you do have to pay for transcripts of the support hearing. So I'm going to turn this back over to Samantha for child custody.
Thank you, Holly. So let's get into talking about child custody. This is by and large the majority of what the courts deal with, because you do not, and just like with child support, you do not have to be married to file for custody of your children. In Pennsylvania, there are two different types of custody. The first kind is what's called legal custody. This is the right to make major life decisions on behalf of your children, such as where they're going to go to school for education, what religion they're going to be brought up under, if any medical decisions that need to be made for your child, and other big, important, potentially life-changing decisions such as that. In Pennsylvania, legal custody can either be shared or it can be sole. Shared means that both parents have a say in the decisions that are made for their children. And sole legal custody means one party makes specific decisions. In some circumstances, we may say that one party has sole legal custody as to healthcare decisions, but the parties have shared legal custody as to everything else. This is something that occurs that is very fact specific, and that often will depend on going before the judge and having a hearing. Generally, though, the courts will want the parties to have shared legal custody, if at all possible, unless there is a very, very good reason for one parent to have sole legal custody, either in one specific area or in all aspects. So that's legal custody. Physical custody is kind of what we think of when we think of custody. It's who the child lives with at any given time. And there are a few more variations of physical custody. And the way I like to describe it is kind of a scale between 0 and 100. If you have primary physical custody, that means you have your children for more than 50% of the time. So 50 to 100. So if you have your children for 50 to 100% of the time, you have primary physical custody. Partial physical custody means you have your children for less than 50% of the time. And shared means that both parents have the children in an equal number of time, 50-50. The slide says here, 182 overnights per year, 7 overnights in a 2-week period. Oftentimes we put these in schedules like what's called 5-2-2-5. Like mom has 5 days, then dad has 2 days, and then the next week mom has 2 days and dad has 5 days, and it just repeats. So 5-2-2-5, or it may be 4-3-3-4 breakdown, week on, week off. There's many different variations of that. And then there's also supervised custody. This supervised custody means that a parent is only seeing the child in a supervised setting. This is usually only done when there are serious safety concerns, or if maybe even a child has been kind of separated from one parent for a long period of time and they need to be gradually reintroduced to having time with that other parent. And supervised custody can be supervised either by a professional entity where you have to pay, or in some circumstances, they can be supervised by a relative or a family friend or some other third party for no cost if the parties agree to it. So what happens in the custody process? And again, this is specific to Allegheny County. Each county may do things a little bit differently. After you file your complaint for custody and you serve it on the other side, the first step is that both parents will go through an education process. This is done all online. It's through a curriculum called Generations, and it basically teaches you about what the new dynamic is going to look like and how this can affect your children and how to try to co-parent effectively with the other parent. The next step is what's called mediation. This can be done either by telephone or video conference, and it's an opportunity for the parties to try to come up with an agreement. If they do, those terms are put in what's called a memorandum of understanding, and that's what the parties can follow. Step 3 says, it says it's signed out. Okay. So step 3 then, if this is your first time filing for custody and there is no custody order already in place, then the court will schedule you for what's called an interim relief hearing. This is scheduled before a hearing officer. Just like the support hearing officers, these are lawyers who have a lot of experience in the area of custody. They have similar judicial powers as the judges do. After the hearing, an order would be entered, basically saying what custody would be. Then the path kind of divides here. If you're only seeking partial custody, less than 50%, you would have another hearing called a partial custody hearing. Then after the hearing officer would issue a recommendation. And just like with support, either party can challenge the hearing officer's recommendation by filing exceptions and going before a judge. If you are looking for shared or primary physical custody, which is 50% or above, or any kind of form of legal custody, then you would go to your next step after the interim relief hearing would be a generations conciliation with a domestic relations officer. Sometimes this is combined with the interim relief hearing, other times it isn't. It depends on the case. If the parties can't resolve it after going before the domestic relations officer or the hearing officer, the parties will be scheduled for a judicial conciliation before the judge. They may have one conciliation before the judge. They may have multiple ones. Each case is different and each family dynamic is different. After judicial conciliations, then you would be scheduled for a trial before the assigned judge. The judge will hear the evidence and testimony, take in consideration a number of factors that they have to consider under the law, and then issue a final custody order. When you're going before a hearing before a judge, all of the judges in Allegheny County have their own standard operating procedures. There are similarities between them, but there are certain things that each judge prefers. All of these judges' standard operating procedures are located on the Fifth Judicial website. If you go to the Family Division tab, and I think it's called Judicial Operating Procedures, you can find a list of all the judges and PDFs of their standard operating procedures. One other avenue you can take if you need the court to act immediately, or quickly, I should say, is what's called a petition for special relief. If an issue has come up and a decision needs to be made before the next scheduled court date, the next hearing date, the matter you can submit a petition for special relief to the judge that is assigned to your case. You have to give the other side at least 7 days notice before the petition is heard by the judge. Most petitions are going to be heard before your assigned judge on their motions court date. And then after the motions court date, the judge will make their decision. If the issue is very urgent and needs to be solved in less than 7 days, then you could do an emergency petition. However, the caveat is that the judge themselves has to determine that it's an emergency. And what are the things that constitute as an emergency? The child is in the hospital and with a life-threatening condition, and they need immediate treatment. The other parent has taken the children and absconded with them out of the state. Urgent matters like that, where we are concerned about the health, the safety, the well-being of the children, those are more likely to be considered emergencies. So in a hearing or a trial, the judge or the hearing officer will decide the custody arrangement with the standard of what is in the best interest of the child. Under recent changes to our custody laws, we have to give judges and hearing officers have to give greater consideration to factors and things that would affect the safety of the child. So there's the next 2 slides talk about some of these factors. Who is more likely to permit contact? Has there been abuse by someone in the household? What are the parental duties? How stable is the other party? Is there siblings, extended family? I want to note for a second number 7 here, preference of a child with child's maturity and judgment under consideration. This is not preference of the child was often determined by doing what's called an in-camera interview, where the judge will meet with the child specifically and talk to them about their preferences. Or a child may be, in very contentious cases, a child may be appointed a guardian ad litem or a best interest attorney or a court-appointed special advocate who can verbalize and represent to the court what is in the best interest or what the child wants and what is in their best interest too. If the child is too young to really verbalize, that's not something that the court often considers too heavily. And some additional factors: who has a loving and stable relationship? How close do you live with each other? Has there been a history of drug and alcohol abuse? Does someone have a mental health condition? Does someone have criminal charges? Certain criminal charges and convictions have to be considered by the courts in making decisions, especially if those charges, it's a very long list, but generally we're talking about violent crimes and crimes committed against a person, as well as, and with the exceptions mainly being DUI and manufacturing drugs. All right, with all of that, I'm going to turn it over to Holly again, who will talk about dependency court.
So I think what's important to understand is that there's something called adult family division and there's something called juvenile family division. And everything we've talked about so far, even the things involving children like child support, custody, they fall under adult family division. And that can be kind of confusing for people for really understandable reasons. You hear juvenile and you think anything involving kids. You hear adult and you think, oh, okay, that must just be adult related. But juvenile has a very specific definition within our court system, and that is that there is some form of dependency or delinquency related to a child, and we're talking about the parent's right to continue parenting in lieu of other options, or the child's potentially having some sort of criminal charges that again implicates a parent's right to a parent because they might be going to juvenile detention or be under probation or being sort of managed by the court. And that's kind of the best way you can think of it, is when we're talking about adult family division, if it involves the children, it involves the rights between the two parents, custody, child support. Yeah, there's also some things like grandparent custody and things like that. But essentially, we're talking about, in general, the parents' rights related to the child financially and in terms of actually having the child. In dependency, we're talking more about state involvement with the child versus parental involvement with the child and where that trumps. So it's oversimplified, but it's a way to think about it because it is confusing. Dependency court is going to handle essentially times where the child is believed to potentially be dependent. And that means that there is no one available who is caring for the child's needs properly or who can't care for the needs properly. It doesn't mean that the parents are bad, right? What it can mean is that a parent has become severely ill and they're hospitalized and the other parent isn't available. That might go into a dependency court. It doesn't have to, right? If there are third parties who are caring adequately for the child and no one seeks dependency, then that's fine. But let's say there's not strong family around, not strong ties, and there's nowhere for the child to go. That might end up in dependency court. I think people always think of dependency court and CYF involvement as meaning one parent is abusive or both parents are abusive. But that's not always the case. It is sometimes the case, but there are other circumstances that could lead to dependency court. Mental health, honestly, is a really big one when there aren't other people around. You're usually not going to be in dependency court if one parent is suitable to care for the child. That would be sort of a custody issue. Or if CYF became involved, they might make a recommendation that, that parent have the child and then you file for custody. This is usually when there is an issue with both parents or one parent is just simply not involved in the child's life or available. There are two types of dependency petitions. The one you'll hear talked about probably most often is when Allegheny County's Children and Youth and Family Services, CYF, you may also hear people call it CPS. That's not the formal name in Pennsylvania, but it's very common, Child Protective Services, alleges that a parent or other caregiver is neglecting or abusing a child and does not meet sort of the minimum standard of care for the child's physical, intellectual, and moral well-being. These are fancy words to say, is the child getting to school? Is the child attending school? Is the child's health care needs being met? Is there food in the home? Is the home kept to a reasonable degree of cleanliness? Is someone physically harming the child in a way that goes beyond sort of standard punishment, right? You're allowed to spank your child in Pennsylvania. You're not allowed to leave a mark. You're not allowed to cause severe pain. So these are cases where CYF may get involved and may file a dependency petition to say to the court, hey, we don't think this child has a safe and reasonable caregiver who can meet the minimum needs of the child. There is a second kind of dependency. I would say it's probably less common, but that's where a third party files for dependency and says, hey, listen, neither of these parents are meeting the child's needs the way they have to, but I'm a private party. CYF hasn't been involved. That could be a grandparent, an aunt, an uncle, a cousin. It could be a guardian ad litem assigned to the child in a different court. But technically, almost anyone can file a dependency petition as long as they have sufficient knowledge to allege that the parents aren't meeting the minimum standard of care. They're handled in largely the same way, except when CYF files it, you know CYF is taking the position, hey, this child is dependent. When a private party files it, CYF may say, we don't think this child is dependent. And so it's more a question of who involved thinks what than it is sort of the path out involved. Common grounds for dependency, like we talked about, lack of proper parental care, education, healthcare, household, food, abuse, habitual and unjustified truancy, missing a lot of school, and there's not really a plan developed or something that's worked out with the school to address it. Habitual disobedience. This one I see less often, but it could be, essentially your child runs away constantly and you can't stop them. And then obviously abuse is always a big one and the most sort of one that's most well known. CYF or the private dependency proponent have to prove the child is dependent as defined by the statute by clear and convincing evidence. This is, it's not proof beyond a reasonable doubt, right? But it's not just a mere showing that maybe something is going on. It has to be clear and convincing to the judge that it's more likely than not that the child's needs are not being met. It can't rely on inadmissible hearsay or vague allegations or innuendo. You got to have people who have seen what has actually happened in the room testifying about it. Children are entitled in dependency court to a guardian ad litem. The guardian ad litem can sometimes provide a certain amount of admissible hearsay, but in general, you got to follow the same rules you follow everywhere else, even though we're looking to protect the child. The dependency process, if we're looking at it from a CYF point of view, and I'm going to stick with that because that's probably the most common, but just keep in mind private dependency does exist and it may follow a slightly different path, although the general outline is the same. The child is removed from the parent's care by CYF, or CYF believes the child is dependent but doesn't have to be removed from the child's care immediately. That can be either. If the child is removed from the parent's care by CYF on an emergency, you have to have what's called a shelter hearing within 72 hours. And at this point, it goes in front of the judge and CYF has to show there's some imminent danger to the child, right? So it's possible that a shelter hearing wouldn't be necessary if the concern is truancy, right? And they think the child's dependent and it needs to be addressed, but there's no immediate imminent danger, right? The court might say, hey, listen, kid can stay at home. We got to work out other structures to support the family and getting the child to school. But if we're talking serious abuse, serious neglect, then of course you have to get the child into foster care, or kinship care, which is care with another family member as soon as possible. Then there's a petition hearing. Basically, what you're trying to have at this point is you discuss sort of the petition for dependency, and then you look at adjudication, which is the child dependent, right? This is the big question, is to get into this sort of path, right? you got to decide the child is dependent and they're not without proper parental care or control. If the child is not dependent, everything ends, right? Go back to the parents, the case is closed, you're done. However, if the child is adjudicated dependent, the judge decides the child meets the definition and the circumstances, then the question becomes, where is the child going to go during this whole dependency process? One option, like we discussed, they can remain with the parents. This would be very common where the CYF in the court believes, hey, these parents need support, they need help, they need programs, they need the kinds of resources that the state can provide or the county can provide, but that the parents can't afford. But we don't believe this child's in danger, and we believe the parents are really engaged in trying to fix the problem. They can be placed with a relative. That's kinship care. I would say that's preferable for everyone usually involved, is if there is someone who can provide for the child that is related to them, that is probably preferable. If someone appropriate is not involved or not willing to take care of the child, or there's no one who has sort of the appropriate resources, then foster care, which would generally be with a third party who isn't known to the family, although sometimes they know them. But those are sort of the options at disposition. Then every 3 months, you're going to have a review hearing, and the review hearing is going to go over what services is the family getting, what is the parents getting, what is the child getting, is the placement still appropriate, are the parents getting visits, how often should they get visits, should they be supervised, should they be overnight, and are we on the path to reunifying the child with the parents? This is going to be so variable based on the children. Like, yes, there's standard things, parenting classes and abuse diversion programs, but it can also look like, has the parent signed up for food stamps to ensure the child has adequate food at home? Is the parent looking for a job? Are they attending education classes? Does the child need special services at school? Do we have a 504 plan if they have mental health issues? Do we have an IEP if they have education issues? And it would go through it. In general, the goal is always reunification. The goal is to reunify the parents and the child and to have the child return to living with their parents and to be able to close the case and say, good, everyone's happy and healthy, and we're in a place where we can close this. However, very commonly, it's going to take a while. And so you continue to have review hearings as you move through that process. If at some point you reach the sort of barrier of the child has been in foster care for 15 of the last 22 months, then CYF can move to file a termination of parental rights. This law changed because children were lingering in foster care for really long periods. Excuse me, while they continued to try to reunify. The goal will remain reunification, but at some point, if the parents aren't participating, it doesn't seem likely the reunification will happen, and you've met the 15 of the last 22 months in foster care, they can move for a termination of parental rights. This is usually called a TPR hearing, and usually you're going to be close. I mean, it might be you're going to be close to 2.5 years by the time you have a TPR. So there's certainly been a lot of opportunity for things to improve. All right. Shelter hearings, I think we talked about. Adjudicatory hearings is when we're figuring out sorry, whether the child is dependent. The child will have a guardian ad litem provided by Kids Voice. They may also get their own attorney if their best interests conflict with what the child wants. The parents always have the right to be notified of all court dates, all motions filed, to attend any proceedings, all decisions made, all orders. They do have a right to an attorney representation in court and in negotiations. That's handled by the Juvenile Court Project in Allegheny County, or of course you're entitled to hire a private attorney of your choice. The Juvenile Court Project is free. And obviously a private attorney can be pricey. You have a right to introduce evidence, to be heard at hearings, to cross-examine witnesses, just like any other litigant. And then you have a right to appeal any final order, including a TPR. I think we talked about most of this. If the child is going to remain in the home and they are declared dependent and there's something going on, the CYF will supervise them and create a family service plan, which is the services the family is going to receive, the child's going to receive. We talked that can include visits, supervised, overnight, non-supervised therapy, educational services, parenting classes, support for finding jobs and resources, mental health support, that sort of thing. Again, we talked, every 90 days, every 3 months, we're going to have a hearing, the goal of reunification or family stabilization. If the family is not meeting the goals of the family service plan, reunification isn't possible. There's no one who can take on a kinship guardianship, like long-term guardianship by a relative. The dependency case can then move to the TPR, termination of parental rights. This goes through what TPR is involved. CYF would have to request a change of goal in the dependency case. That's going to be a hearing. Parents have a right to be heard. At the TPR petition, parents have a right to be heard. Again, you were entitled to attorneys. There is discovery. You can enter evidence. And then the court will take evidence and render its decision. If you don't agree with the decision, especially if there's a TPR finding where the parent's rights are going to be terminated, it can go to appellate court to decide if that's appropriate. Once a TPR happens, and the parents' rights to the children are terminated permanently, the child can be put up for adoption. If the child is of a certain age, they may go into more of a transition group home where they're going to be set up with resources until they get to, adulthood. Foster children and children with TPRs have certain rights under state law. They may be entitled to Medicaid. They may be entitled to help with college and other support. So it's going to depend on the child's age and sort of the availability of things. But the important thing is to understand from the parent point of view is you become legally a stranger to your child if your rights are terminated. That means you have to think about what that means for everything, not just your right to have your child as a child, but if you reestablish a relationship in adulthood, which isn't uncommon, especially with older children whose biological parents' parental rights are terminated. If you wanted to leave your children things, upon your death, you'd have to create a will because they're no longer entitled under, law if you don't have a will because they are a stranger to you under the law. These are the statutes in some case law related to termination of parental rights. I think pointing out it's very fact specific is correct. It is every family is a little bit different. You got to look at credibility of testimony. You got to look at evidence. And then it is, again, a clear and convincing standard. And the court has said, so clear, direct, weighty, and convincing to enable the trier of fact to come to a clear conviction without hesitance of the truth of the precise facts and issue that the child's the parent should have their parental rights terminated. So I think that's the end of what we have here. I don't know if there are any questions, but I do want to say if you are at 187.5% of the poverty line in your household income and you need help with a family law issue, you are more than welcome to call the University of Pittsburgh or the Duquesne University's family law clinics, which can offer some form of support in the legal process. And thank you for having us.